Welcome back to the Deep Dive. Today, we're diving headfirst, really, into one of the most intellectually challenging and, well, ethically complex fields out there. The intersection of the human mind and the justice system.
It really is.
We are unpacking a pretty comprehensive stack of source material, straight from a core textbook of psychiatry.
And it's such an essential deep dive because, the law just assumes that every adult has mental capacity. It's the baseline.
Right.
But the moment that capacity gets questioned, maybe someone's choosing a treatment or facing a criminal charge, maybe even just writing a will, the legal system immediately calls on psychiatry.
So our mission today is to take those foundational ethical frameworks, the legal standards, the core conflicts that really define forensic psychiatry, and try to make them structured, accessible, and hopefully crystal clear for you, the listener. Okay, so let's start right at the foundation, the doctor-patient relationship itself. Historically, it wasn't always about patient choice, was it?
Not at all. The old model was very paternalistic. It rested on this idea of beneficence, the doctor's duty to do good.
Which often meant?
Which often meant the doctor decided and, informed the patient. It wasn't really a partnership. That whole paradigm shifted dramatically when the concept of patient autonomy, the right to self-determination, really took center stage.
And there's actual legal history here.
Oh, yeah. The key legal backing is, surprisingly, pretty old. It goes back to 1914, believe it or not. A case called Schloendorf v. Society of New York Hospital.
1914.
Yeah. And Justice Cardozo wrote something that basically set the stage for modern medical ethics. Every human being of adult years and sound mind has a right to determine what shall be done with his own body. That's the bedrock.
And that bedrock, right? It leads directly to what we now call the informed consent doctrine.
Exactly.
Our sources say there are three crucial parts for consent to be, legally real.
That's right. Three essential elements. First, there has to be disclosure. Meaning, the physician has to provide all the relevant facts. The diagnosis, the proposed treatment, the risks, the benefits, any alternatives.
And what happens if you refuse?
And the consequences of refusal, yes. Now, what's interesting is that different places might use slightly different yardsticks for how much information is enough.
Oh, like different standards for disclosure?
Yeah. You've got the physician-based standard, basically what a reasonable doctor in that situation would tell you.
Okay, that makes sense.
But then there's the patient-based standard. And that one, it shifts the focus. It's about what a reasonable patient would want or need to know to make their decision.
So that could include things the doctor might think are minor, but the patient would find really important.
Precisely. It forces the doctor to think from the patient's perspective. Okay, so that's disclosure. The second element is voluntariness.
How straightforward.
It mostly is. It just means the patient's decision has to be free from coercion. No threats, no manipulation, just their own unforced choice.
Makes sense. And number three?
Number three is capacity. And this is where people often get confused. Capacity versus competence. They sound similar.
Yeah, I admit I mix them up. Can we draw a really clear line there?
Let's do it. It's a critical difference. Capacity is a clinical judgment. A doctor, usually a psychiatrist, assesses if the patient has the mental ability to understand the information they've been given, appreciate the situation, and use that info to make a rational choice about treatment.
Okay, clinical assessment. Capacity.
Right. Competence, on the other hand, is a legal determination. It's made by a judge in a court. The psychiatrist provides the court with their assessment of the patient's capacity, but it's the judge who makes the final legal ruling on competence.
Got it. So the doctor advises on capacity, the court decides competence.
You got it.
Now, what happens if that capacity is, lacking, or if competence is legally denied? The state can step in, right? Involuntary treatment, hospitalization.
Yes, and the state usually relies on two traditional legal justifications for that kind of intervention.
Okay, what are they?
First is parens patriae. It's Latin, basically means parent of the country. It's the government's power to act as guardian for those who can't care for themselves. Think intervening to prevent someone from serious self-harm because they don't understand the danger.
Okay, the state as protector of the vulnerable.
Right. And the second is police power. This one is about protecting the public. If a person poses a danger to others due to mental illness, the state can intervene using its police power.
So protecting the individual versus protecting society.
Essentially, yes. And crucially, The standard of proof needed for civil commitment, that's involuntary hospitalization, is usually clear and convincing evidence.
Clear and convincing. How does that compare to, say, a criminal trial?
It's a higher bar than the preponderance of the evidence used in most civil cases, but it's lower than the beyond a reasonable doubt standard needed to convict someone of a crime.
So it's serious, but not as demanding as proving guilt in a criminal court.
Exactly. Which makes sense, given you're taking away someone's liberty, but the goal isn't punishment. In these situations, especially involuntary ones, they throw psychiatrists right into a philosophical maze. Which brings us nicely to the underlying ethical frameworks.
Right, because how do you decide what's right when these principles clash? Our sources mention two big schools of thought. First, there's deontologic ethics. Sounds very philosophical.
It is. Think Immanuel Kant. This approach focuses entirely on duty and intention. The consequences of your action don't determine if it's right or wrong. It's about following the rule, doing your duty.
So the ends don't justify the means.
Exactly. The core idea is Kant's categorical imperative, a key part of which says you must never treat another person merely as a means to an end, but always as an end in themselves. Respect for the person is paramount.
Okay, duty-based. What's the alternative view?
The alternative is utilitarianism, associated with thinkers like Bentham and John Stuart Mill. This completely flips the script.
How so?
It's all about the consequences. An action is considered right if it produces the greatest amount of good for the greatest number of people.
Ah, the greater good argument.
Precisely. So here, the ends can justify the means. If an action leads to the best overall outcome for society, it's ethically justifiable, even if it infringes on one person's interests.
But wait, how does that square with patient autonomy? If you're always focused on the greatest good, doesn't the individual patient sometimes lose out? That seems like a direct conflict for a doctor.
It absolutely is, and that's the core ethical tension in medicine, and especially forensic psychiatry. In practice, psychiatrists don't rigidly follow just one model.
So it's more of a blend.
Kind of. They generally operate using what are called the four basic biomedical principles. Think of them as guiding lights.
Okay, what are the four?
Autonomy, which we discuss, respecting the patient's right to choose. Beneficence, the duty to do good, to help the patient. Nonmaleficence, the duty to do no harm, or at least avoid unnecessary harm. And justice, fairness, basically. Equitable distribution of benefits and burdens.
Autonomy, beneficence, non-maleficence, justice.
Right, and the really tricky ethical dilemmas pop up when these principles conflict. For example, autonomy versus non-maleficence. Think about physician-assisted dying. The patient's autonomous choice might conflict with the physician's duty to avoid harm.
That makes sense. Another huge conflict area must be privacy, confidentiality versus privilege. What's the difference there?
Good question. They're related but distinct. Confidentiality is the broad ethical and legal duty of the clinician not to disclose information shared by the patient without their consent. It's fundamental to trust.
Okay, the doctor's duty to keep quiet.
Yes. Privilege or testimonial privilege is more specific. It's the patient's legal right to prevent their confidential information from being used as evidence or compelled in a legal proceeding, like the courtroom.
So confidentiality is a doctor's obligation.
Yeah.
Privilege is the patient's right in court.
You've got it. The patient holds the privilege and is generally the only one who can waive it, allowing the information into court.
There are exceptions, right? I feel like there's a big one looming.
There is. The major and probably most stressful exception for clinicians is the duty to warn or duty to protect.
Ah, yes. The Tarasov case.
Exactly. Tarasov v. Regents of the University of California, 1976. This landmark case established that mental health professionals have a legal duty to take steps to protect an identifiable third party if their patient presents a serious danger of violence towards that person.
So if a patient makes a credible threat against someone specific,
the therapist may have a legal obligation to breach confidentiality, perhaps by warning the potential victim, notifying police, or taking other steps to prevent the harm. It created a huge stir because it legally mandated that public safety could, in specific circumstances, override absolute patient confidentiality.
a massive ethical tightrope.
Absolutely. Okay, shifting slightly to liability. If things go wrong, we hear about malpractice. What actually constitutes psychiatric malpractice legally?
The sources mention the 4Ds. Sounds like a checklist.
It basically is. To win a malpractice suit, the plaintiff, the patient, usually has to prove four things by a preponderance of the evidence, which means more likely than not.
Okay, D number 1.
Duty. It has to be shown that a doctor-patient relationship existed, creating a duty of care.
Simple enough. Number 2.
Dereliction. This means there was a breach of that duty. The psychiatrist failed to meet the expected standard of care. Importantly, this isn't about perfect care. It's about what a reasonably prudent peer, another psychiatrist in a similar situation, would have done.
Okay, so dereliction is falling below the standard. What's D number 3?
Direct causation. There needs to be a direct link between the psychiatrist's breach of duty and the patient's injury. You have to show that, but for the psychiatrist's negligence, the harm wouldn't have occurred.
The breach caused the harm. Got it. And finally,
Damages. The patient must have suffered actual harm or injury. Physical, emotional, financial. That can be compensated, usually with money.
duty, dereliction, direct causation, damages, the 4 Ds.
Correct. Although there's a fascinating exception mentioned in the sources.
Oh.
It's a legal doctrine called res ipsa loquitur.
Latin again. What does that mean?
The thing speaks for itself. It
Huh.
applies in situations where the negligence is considered so obvious that it likely wouldn't have happened unless someone was negligent. Think leaving a surgical instrument inside a patient.
Or maybe
Hmm.
sexual misconduct by a therapist.
Exactly. In cases like sexual misconduct, which the APA explicitly states is inherently exploitative, res ipsa loquitur might apply. It essentially shifts the burden of proof. Instead of the patient proving all 4 Ds, the situation itself implies negligence, and the physician might have to prove they weren't negligent.
Wow, okay. That relates to boundaries too, right? The
Yeah.
sources mentioned violations versus crossings.
Yes, an important distinction. Boundary violations are actions that harm the patient or exploit the relationship for the physician's benefit. Sexual intimacy is the clearest example. Boundary crossings, however, are departures from usual practice that are potentially helpful or harmless, maybe even beneficial to the patient, like accepting a very small, inexpensive gift at the end of therapy.
So context and intent matter hugely.
Critically.
Okay, this leads us perfectly into what seems like the biggest ethical tightrope of all. The difference between being someone's regular treating psychiatrist and acting as a forensic expert for the legal system. The sources say these roles fundamentally conflict.
They absolutely do. It's a core tension. Think about the therapeutic role. What's paramount there?
Trust, believing the patient, helping them.
Exactly. The psychiatrist generally accepts the patient's subjective experience, their narrative truth, to build rapport and facilitate healing. But in the forensic expert role, the game changes completely. The psychiatrist's primary duty isn't to the patient's therapeutic well-being, it's to the court or the legal question at hand. They have to be objective, even skeptical. They need to evaluate the information presented, compare it with other evidence, collateral sources.
So they can't just take the person's story at face value like they might in therapy.
Right. They have to consider the possibility of exaggeration, minimization, even outright malingering, because the legal stakes are high. It requires a different mindset, objective analysis, rather than therapeutic alliance.
That sounds incredibly difficult to switch between. One minute you're their ally, the next you're scrutinizing their claims for a judge.
It's a profound conflict, both ethically and practically. That's why the strong recommendation, the best practice according to our sources, is to separate the roles whenever possible.
So your treating doctor shouldn't ideally be the one testifying about your sanity in court.
Ideally, no. A separate, independent forensic evaluator is preferred to avoid that conflict of loyalty and methodology.
Okay, so when a psychiatrist is acting as a forensic expert, what kind of legal questions are they usually answering? Let's start with criminal stuff.
A major area is assessing criminal competencies. The law presumes competence, so the question is whether a mental disorder renders someone incompetent for some legal purpose.
And the most common one is?
By far, the most frequent evaluation is competency to stand trial. The standard comes from a 1960 Supreme Court case, Dusky v. U.S.
Okay, what does Dusky require?
It's a 2-part test focused on the defendant's present ability. 1. Does the defendant have a rational and factual understanding of the charges and the court proceedings?
Do they get what's happening?
Basically, yes. And 2, can they consult with their lawyer with a reasonable degree of rational understanding? Can they assist in their own defense?
Understand the process, assist the lawyer. Seems clear. Are there other criminal competencies?
Yes. Another significant one, though rarer, is competency to be executed. A 1986 case, Ford v. Wainwright, ruled it unconstitutional to execute someone who is unaware of the punishment they are about to suffer and the reason for it. They have to understand the reality of the death penalty and why it's being imposed on them.
So competence is about their mental state now. during the legal process.
Yeah.
What about their state of mind back when the crime happened? That's
Yeah.
the insanity defense, right?
Exactly. That's criminal responsibility, not competency. It asks whether, due to mental illness at the time of the offense, the person lacked the necessary mental state, the mens rea or guilty mind, to be held legally responsible for their actions.
And different places use different rules for this, too.
Yes, the standards have evolved and vary by jurisdiction. One of the oldest and most famous is the Knighton standard from England in 1843.
Not, what does that say?
It's very cognitive, it asks. At the time of the act, did the defendant, due to mental disease or defect, not know the nature and quality of the act they were doing? Or if they did know it, did they not know that what they were doing was wrong?
So it's about knowing what you're doing or knowing it's wrong.
Right, two cognitive prongs. A more modern standard, influential though not used everywhere now, is the American Law Institute, ALI, standard.
How is that different?
The ALI standard broadens things. It says a person isn't responsible if, due to mental disease or defect, they lacked substantial capacity either to appreciate the criminality or wrongfulness of their conduct,
Okay, similar to McKnighton's cognitive part.
or to conform their conduct to the requirements of the law. That second part adds a volitional element.
Control element. Like maybe they knew it was wrong but couldn't stop themselves.
Precisely. It acknowledges that some mental illnesses might impair impulse control or the ability to act in accordance with one's understanding, not just impair understanding itself.
Fascinating difference. Okay, moving away from criminal law for a sec. What about on the civil side? Wills seem like a common area.
Absolutely. Psychiatrists are often asked to assess testamentary capacity, the mental capacity needed to make a valid will.
Is the bar high for that? Like, do you need to be perfectly sharp?
Actually, no. The legal standard for testamentary capacity is generally considered quite low compared to other competencies.
Really? What does it require?
The person making the will, the testator, basically needs to understand four things at the time they sign the will. One, that they are signing a will, an instrument that disposes of their property after death.
Okay, no, it's a will.
Two, they need a general idea of the nature and extent of their property. Not every stock certificate, but a basic sense of what they own.
Know what they have. Got it.
Three, they need to understand the plan for disposing of that property, who gets what.
Know who gets the stuff.
And four, they need to know who their natural objects of bounty are, typically. Their closest family members or relatives the people society would normally expect them to provide for.
Know the family. So will, property, plan, family. That's it.
That's essentially it. Importantly, someone can have, say, mild dementia or other cognitive issues, but still possess sufficient testamentary capacity on a given day if they understand those four elements when executing the will.
Let's shift to our final segment, correctional psychiatry. The sources paint a really grim picture here, calling it a public health crisis due to the criminalization of the mentally ill.
It is genuinely shocking when you look at the numbers. Decades of factors like deinstitutionalization, closing down state hospitals without building up enough community mental health resources, plus things like zero-tolerance crime policies.
You created a perfect storm.
The perfect storm.
Yeah.
The result is that jails and prisons have become effectively the largest mental health institutions in the country. Estimates suggest somewhere between 20% and 40% of people incarcerated have a serious and persistent mental illness, like schizophrenia or severe bipolar disorder.
20 to 40%. That's staggering.
It translates to potentially over 350,000 individuals with serious mental illness locked up in correctional facilities. Compare that to maybe only 35,000 patients in actual state psychiatric hospitals nationwide.
So 10 times as many seriously mentally ill people in jail or prison than in hospitals designed to treat them.
That's the scale of the problem. It's massive.
And once someone with mental illness is incarcerated, the state still has obligations, right?
Absolutely. There's a constitutional mandate. The key case here is Estelle v. Gamble, a 1976 Supreme Court decision.
What did Estelle establish?
It established that deliberate indifference by prison officials to the serious medical needs of inmates violates the Eighth Amendment's prohibition against cruel and unusual punishment. And importantly, medical needs explicitly include serious psychiatric needs.
So prisons can't just ignore serious mental illness. They have a duty to provide care.
They have a constitutional duty, but delivering that care inside a correctional setting creates that intense dual loyalty problem for psychiatrists working there.
Right, who are they working for, the patient or the prison?
Exactly. They have an ethical duty to their patient, but they're also employed by the correctional agency, which has security and institutional management as its top priorities. These duties can easily clash.
How do they navigate that?
Transparency is key. The sources emphasize that correctional psychiatrists must be very clear with inmate patients from the outset about the limits of confidentiality in that setting. Certain information might have to be shared for safety or security reasons.
So informed consent looks different there too.
It has to. And professional guidelines, like those from the National Commission on Correctional Healthcare, NCCHC, explicitly state that mental health staff should not participate in gathering forensic information like details about the inmate's crime that could be used against them in disciplinary hearings or legal proceedings. Their role is treatment, not investigation.
That separation seems crucial. Another grim aspect mentioned is suicide risk.
Tragically high. Suicide rates, especially for men in local jails, are estimated to be something like 9 to 15 times higher than in the general male population.
9 to 15 times. Why so high? Are there specific danger periods?
Yes. Clinicians need to be hypervigilant during certain high-risk times. Right after admission is a big one, the shock and despair. Also, after receiving bad news about their case, or significantly, when placed in solitary confinement or administrative segregation, isolation is incredibly detrimental.
It's a really challenging environment for mental health. Are there any hopeful directions? What's the future look like?
The focus is increasingly on trying to stop people from ending up there in the first place. So diversion programs are a major push.
Diversion, like intercepting them earlier.
Exactly. Pre-booking diversion, where police might take someone to a crisis center instead of jail, or post-booking diversion, where someone is released from jail into a mandated community treatment program. The goal is to get nonviolent offenders with mental illness out of the criminal justice system and into treatment systems.
That makes so much sense.
Yeah.
What about inside the facilities?
Staffing is always a huge challenge, especially in rural or remote areas. So telepsychiatry is becoming increasingly important. Using video conferencing allows psychiatrists to provide consultations and even ongoing therapy to inmates in facilities they can't physically travel to regularly. It expands access.
Using technology to bridge the gap.
Mm.
Okay, wow. As we wrap up this deep dive, what really stands out to me is just this constant inherent tension the psychiatrist has to manage. You know, the legal world wants certainty, clear answers. Are they competent? Yes or no. Are they responsible? Yes or no.
Right, the law deals in binaries.
But psychiatry deals with shades of gray, with fluctuating capacity, with the messy ethics of care versus control.
Precisely. That's the core challenge. Whether it's upholding a patient's right to refuse treatment versus the state's duty to protect them under parens patriae, or balancing confidentiality against the duty to warn under Tarasov, or navigating that dual loyalty in corrections.
It's always a balancing act.
Always. The forensic psychiatrist is constantly navigating this complex space between an individual's rights and autonomy on one side and society's legitimate needs for safety, order, and justice on the other.
Well, thank you for joining us for this really complex, but I think incredibly important deep dive into psychiatric ethics and forensic practice. It definitely gives you a lot to think about. And for you listening, maybe consider what element of that informed consent framework, disclosure, voluntariness, capacity will you reflect on the next time you face a significant decision in your own life?